afternoon, everybody. Welcome to the July 9th meeting of the Planning Board of the Village of West Hampton Beach. Please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Whistle's going off for me. We're going to start with a resolution, West Hampton Associates LLC, 123 through 129 Main Street. I need a motion to accept the resolution as written.
So moved.
Second. All in favor?
Aye.
We're going to go out of sequence a little bit. Beaver Lake Development Corporation, 36 Sunset Avenue. Mr. Hafley, good evening.
Good evening. We submitted the application and we're just trying to find out if that's satisfactory to you as far as the layout before we go further with doing the rest of what we have to do.
Can we start with you guys and give us your professional input on this application, please?
Well, what I see layout is very preliminary. Being farmed for the south side, but now details on the side we want to build.
I'm sorry, I can't,
I need the details on the side you want to build. You know, I mean, details, drainage, and all the photogrammetrics, all the stuff that you typically have on a site plan of what you want to build.
okay, I just want to know if the layout is okay. We have to come back to do.
Layout is okay.
I wrote a memo that had a lot of specifics about lighting and landscaping, and we've
I
had
have to do
any
all
role,
that, I
so I
understand.
think he'll address those.
Yeah, I mean,
We'd like to address them.
this is very close to what we looked at last time, it's conceptual, there's a couple more details. The same, I think it's still conceptual, but I think I'm okay with it.
Well, do we have any input from the neighbor when it comes to that?
We have
front-
their neighbor's attorney here, so let's
Okay,
maybe hear from her.
we haven't yet.
Okay.
I specifically called the neighbor. I told him what we were doing and everything else. So that he's aware, he's definitely aware of the fact. It's the he, not, they sold the property. And I spoke with the new owner.
All right,
Between
well,
the last time
we'll
I
see
was
how
there-
that evolves, because we'll see how that evolves. You speaking to them doesn't do anything for this board, okay? We need things in writing. You may know that.
You want something from the neighbor in writing? I mean, whatever you want, I will. I advised him that this was on, I advised him that we were using his parking area. And
Okay. All right, well, then we'll wait for their response
from him.
from their attorney.
Oh, you hear?
I'm here for that.
Oh, okay. Fine.
Hello.
Good evening.
Heather Wright for the owner of 50 Sunset Avenue. I just got retained on this. I've had an opportunity only to look at the agreement that was, I guess, on file on both the declaration, and I've spoken to my clients about it. You know, the way I read this agreement is that it's really subject to whether or not both owners of the parcels can agree to a reasonable coordinated parking plan. And at this time, my client's not interested in a parking plan that involves their property here, and I don't think it's required under this agreement. So I would suggest that perhaps the owner of 36 Sunset explore other options for that cross access, which I think is available to them.
Okay.
Okay.
Do our experts have any other comments?
This whole corner really wasn't a very good parking place. We just were looking for a cross access. Essentially, so people could, besides his driveway was this property, not large enough to handle two-way traffic. Here, when we asked for cross access, so that we could allow that traffic out through the adjacent property, we cross access.
Well, we'd also discussed the Glover's Lane opportunity here too, which seems to be the elephant in the living room. So,
so sure. I mean, it's,
Like, I don't
this
think
is the document that was done, whenever it was done before my time, before I assume all of your time. It's not perfect. It's not the kind of cross access that we would use today. Where it's today we make cross access where it's crystal clear that I am offering it irrevocably, and if the other side complies and offers it irrevocably, it's triggered and the cross access becomes live, right? It's not a terrific document, and I'm not sure that
Wonder who was the
that-
village attorney at that time?
I'm not saying, don't, I have no idea. It's 1994, March of 1994. My point is that if the other side hasn't truly offered cross access, I don't know where that leaves us for this property, because, the reason they went to this cross access was because they don't want to provide the rear access, which was the first thing that the planners and engineers suggested was the right way to handle it. Now that they're offering cross access as an alternative, but if the cross access isn't real, where does that leave us? That has to be looked at. I don't know the answer to that, because it's
Well, that's not something.
having
this
something
board-
on paper, Mr. Chairman, that doesn't actually work in reality because the other side won't allow it, isn't a solution necessarily, unless it's, I don't know, coupled with some certainty that the other side will end up agreeing to. So I don't know where that leaves us.
I don't think we have any action on this at this
No,
moment.
not right now, but if nothing gives, so if the applicant doesn't present an agreement from the neighbor and won't relocate the access to the Glover's Lane side, I'm not sure what that means. That's something the board's
then
gonna
what-
have to revisit at that time.
What does this agreement, if it's not a perfect cross-access, what, if anything, does it offer us,
Nothing.
barring some, elected, judge up on Court Street looking at it for the next year or so and letting us know? I mean, that's pretty much where it sounds like this is gonna go.
Maybe.
If we impose it,
Impose what?
impose a cross-access, because there may or may not be a cross-access. I don't know.
Well, there's gonna be a cross access. The question is, where's it gonna be?
Well,
And at this
no,
moment, the
that's-
representation we have doesn't reflect reality.
Well, it doesn't sound to me as if the adjacent property owner is interested in cross-access, joint parking, whatever the hell you wanna call it. It doesn't sound like they're gonna be willing to allow access across the property line. They're gonna want that solid. So what do we have then from 1994? What the hell is it?
Well,
That's
don't
what-
know.
That's what I'm wondering.
I don't
'cause
know
if it's
either,
not that, then
because
what
it
is
says,
it?
because David says they will enter into an agreement, a reciprocal parking agreement. You're a lawyer and I'm a
So
lawyer.
you cannot have.
We're
a
all lawyers.
cross- I ca- you
It's an
can't have a-
agreement to agree.
agreement to an
and
agree, so
agreements to
then-
agree aren't really enforceable, but maybe Mr. Hafley could take it to court and get it enforced. I don't know. I don't know either.
All right, well, we have no action on this, so we're just going to close the discussion for tonight and move on to the next application.
Where does that leave? I'm just trying to find out where that leaves us, that's all.
You heard where it leaves us. It leaves us nowhere. You've got nothing to present to us.
I don't have anything to present to you.
No,
I didn't present to you what took place in 19, whatever it was, as to the use of.
it
the
has no
property.
validity in this conversation.
That's not valid. You're saying to me that's not valid?
I'm not saying anything about the validity of it. That's up to you, not to us.
We have you saying, here's an agreement, and we have the other side saying, we don't recognize that as a quote unquote agreement, right? I think that's the way to put it. And so,
Wait a second, there's an agreement of record, okay? I don't care whether or not she wants to agree to it or not. It's an agreement of record that the then owner of that property agreed to.
But they don't own it anymore.
But they agreed to it, and they got an approval to do what they wanted to do, to change it from a house to a bookstore as a result of that agreement.
But is it the village's responsibility to enforce that, or is it your responsibility to go to court and enforce that upon the adjacent property owner?
It's your
We're-
responsibility.
No, we're not responsible for enforcing
For an
a
agreement that
private
you-
contractual agreement between two parties. We're not a party to the contract. It's just part of the-
Party
it's-
to the agreement when
Party-
it was
no, we're
entered
party-
into.
No,
You-
you're party
you-
to a
you
site plan.
approved it. You
approved
approved
the
the
site plan.
agreement.
So I can approve anything I want, doesn't mean I have.
It's a private agreement.
Yeah,
Excuse me?
It's a
it's
private
a
agreement.
private contractual right.
Not a private agreement.
It's
It's
not
an
too
agreement
dissimilar to
that
what was
included
going on.
All right,
on
all right, all right,
Lilac.
all right, all
Let-
right,
let me-
all right. That's it.
Let me, before you, I think you need to have further discussions with Heather and her client to
Well,
see.
She never told me until tonight that she was
Okay.
even representing.
Okay, so now you know,
I know.
and you can now have conversations with them to see if you can work it out, because at this point, we have a declaration that doesn't run to the benefit of the village. So there's nothing in this document that says it's enforceable by the village. So let me finish. That's where we are as a board, right? She's saying they don't recognize it as an enforceable agreement. You're saying it is. Maybe it is, maybe it isn't. It's gonna be incumbent on you, if you can't work it out with them, to get them to agree to something, to either get some declaration from a court that requires them to participate, or come up with Plan B. Because there is a Plan B out there, and you know there is one, and it's as easy for you to deal with as the plan you're trying to use right now. So either get them to agree to it, get a court order requiring it, or go to Plan B and provide a different access.
All right, we'll put it over.
Okay?
Thank you, Mr. Hafley. We're gonna go to Mona Gorda right now. 302 Dune Road. This started out as a fill application. We're now talking about the sports court, and I guess the expanded driveway is irrelevant. That's part of it.
Good evening.
Good
Stephen
evening.
Rhoda with Aris Design Landscape Architecture. On behalf of the owner, Mona Gore is here as well. So I wasn't here at the last meeting. My associate was, but I know you guys wanted to get a little more information about Powell or Bedell. And then we also submitted landscape plan as you requested.
So we're looking for comments from our experts.
Yeah, so what you submitted, shows the glass going up to under 10 feet and then this mesh above, which we can't have for village code, so that was an email that
Right.
I think your associates.
No, yeah, it's not a problem to remove that.
As far as I'm concerned, building code wise, zoning code wise, as long as this wall is less than 10 feet, I'm okay with that. But it can't go beyond 10 feet, because otherwise it doesn't conform to zoning.
So the plans as we have them right now are incorrect.
Correct, what was submitted shows this thing. on
Good.
top.
Shows-
Typically for Bedell Court, you have.
Well, we need the
you have a
plan
glass
that
wall.
we have to approve, so.
No, yeah, no, I understand. I'm just want to let you know, typically for a glass wall, it's usually upwards of almost 10 feet. And then there's a 3-foot height black mesh above it. Brad reached out to us, said, we'll have to remove that. We said, no problem. We're just, that comes off. That's not a problem.
Yeah, you should just follow up
But
with the
that's
plan that
typical.
shows without, showing that the maximum height of this entire surround, whatever it is, wall, mesh, whatever, is less than 10 feet.
Yep.
10 feet is also a building code trigger, and it's very hard for you to apply.
Yeah, on our details,
to
yeah,
glass when it gets to 10 feet.
sure. It does go, it is less than 10 feet, yeah.
That was my comment
Mhm.
last time, so we asked for more information,
Yep.
but we should have a plan that shows it's 9, 8, whatever.
Which that plan has that was submitted. We have the details on that was submitted to you.
Oh, okay, I
Yeah.
just had the one that just says mesh.
Yeah, that's in there.
That's the one I have too.
But we have to update it to remove the mesh
Okay, yeah.
based on your comment. That's it, yeah.
Let's do that.
So
Ron, do you have any comments regarding the fill or anything pertinent?
Two, one, type of tree, screen, height, width,
is noted on the plan. It'll absolutely be irrigated.
Lighting and everything?
Well, if they're gonna do lighting, then naturally shouldn't have lighting.
You know, it's not, we don't plan to have lighting. No,
I don't think that's appropriate.
we wouldn't normally do that.
Brendan?
Um,
Don, would you like to start?
So the netting above the glass is, would equal the total wall of 13.1 inch, my understanding, for an official court.
Right. It would, if we use that netting, correct. It's another
That's
3
correct,
feet
on
on
both
top.
sides.
Right.
Now, why do they have that netting? They have it so that the ball doesn't go over into someone's yard or so forth.
Right,
correct?
exactly. Yeah, it's just another extra barrier.
Okay.
Yeah.
The same reason why we have tennis courts that go 10 feet high is so that the ball isn't going on the neighbor's yard.
Right.
Okay,
Yeah.
so really, to play an official game, you really need that netting, don't you?
Not really. It's not an important part of the game. It's extra there. Really, the glass wall is what's happening. That the ball's bouncing off the wall
Okay.
and hitting off, but that netting is really just there as an extra barrier. It's not.
And the decibel level on a ball hitting that wall is the whole game is higher than a tennis game, I understand, but
Well, it just has it has that additional sound, like with a tennis court or a tennis game, it's the hitting back and forth with the racket. With padel or a paddle, it's the same kind of hitting. It's like a tennis ball with a racket, but then you have it's hitting the glass wall. It's not a loud noise that's hitting. And it's not something. It's not every time the ball's hitting. It's just sort of in the background. If it goes past the player, it'll bounce off the wall and they'll hit it.
my understanding is, sports courts are treated like accessory buildings, okay? And they should go through that process.
Right.
Wouldn't you rather have an official court and go through the BZA to have maybe 13.1?
We already have approval for a tennis court to be in that location.
That's 10 feet, that's it.
Yeah, and that'd be a 10-foot chain link fence, and it would be approximately where that approved location is. It would be 20 feet off the road
Okay.
edge. Currently, we're proposing this is the court is set back almost 60 feet off of the road.
I saw,
it's
got the idea. Yeah.
quite a bit distance from the road now, and the padel court is half the size of a tennis court, and it's also a
Yes.
permeable surface.
Right.
So there's a lot of pros to that, and it's really a sports court. We really want to have it to accommodate grandkids playing on it. It's nice that it's
Yeah.
turf.
Has to be played with 4 players.
I've seen it with 2, but yeah, 4 is typical.
That's what
Yeah.
they say, yeah.
Isn't that sound somewhat contained by the glass that's on 3 sides?
The glass is a sound attenuator, so it has that function.
Yeah.
And what's nice about the glass is it's completely transparent.
So there's no plans to put the net up on the top of 3 feet?
No, per Brad's request, we would not do that.
Any more, Larry?
Nope.
2, the glass itself, I'm concerned about the reflectivity of it. Is there any opaqueness to it? Is there any light diffusing? So that, if you are down off of the water,
Yeah.
certain times of the day you will get angles of the sun which could reflect on towards the boater to boaters, onto the adjacent property owners. That's one thought.
Yeah.
That's one thing. But that may or may not be an issue because your colleague was here, said that this is actually being constructed below grade. So how far below grade are we?
Well, it's below grade from the street. If you're standing at the street,
Right.
The grade elevation of the street is approximately 8.5 feet. The tennis or the padel court would be set 2.5 feet lower than that. The base of it would be.
So the proposed landscaping, the trees or whatever the hell is there, what is the anticipated height? Will it be more than 10 feet? Will they be
Oh, the
higher?
landscape, yes, the proposed
Will
landscape.
they be higher than the walls? Then
the
you
yeah.
have less of an issue.
The concept there is we'll have plantings all along the street frontage, along the property line. Linden trees, so these big trees
Right.
crown out. And then we have fastigiate evergreen trees against the padel court itself.
Yeah, my only concern with that was the reflectivity of the potential
Sure.
reflectivity of the grass. But if that is screened from the adjacent property owners and is actually slightly below grade,
And
yeah, then I think
plan
you're in
that we
business. Yeah.
just asked them to
Yeah.
revise, per Ron's suggestion, we'll have those
Yeah.
growths on the.
That was only because we haven't really dealt with a pedal course. I think we're just kind of have the
Yeah,
discussion so we
totally,
can
yeah.
kind of
Absolutely.
decide in the future where we're going with
And the
this.
intent too with the tennis court, we went back and forth with that because it's a tough one to give up, is having a tennis court in your yard. But the owner, Mona, really loves landscape, and the whole idea is to get to the plantings and the landscape. By decreasing the size and going to the Bedell gives us an opportunity to plant more, and that was really our goal there too. It was sort of win-win for us. That's what we were hoping for.
That's it for you?
That's it for me.
Rocco?
I'm good.
Okay.
I've heard everything.
Can we take an action this evening?
No, but you could do a straw poll if you want. I know they were looking for some guidance as to whether, the last time they were looking for guidance as to whether this would be approved, so they could start the order. We need to do a written decision on this, right?
The board should approve it subject to drawing that shows it doesn't exceed 10 feet, right?
No, I know, what I'm saying is you could do a straw poll, let them know what you're thinking, and then once they submit the corrected plans, you can have a written decision ready for the next meeting. Assuming that's where you're going.
Okay,
I don't want to be presumptuous, but.
thank you. Don, you have more to
Chairman,
add?
can we get an addendum to this decision where the applicant commits that the screening will not go on at any point? The additional screening at three feet? Can we get a document from that?
Well, that's the question for the
I don't
attorney.
understand. What's the question?
He's concerned that they're gonna add 3 feet of netting at some
Or
point.
maybe the next,
After the
or maybe
courts.
the next owner would, or whatever.
Well-
You don't know.
You can't, look,
That's why I'm asking.
they can't legally do it without a building permit. He can't give a building permit without a variance. So that's the process that they'd have to follow. We can't force someone to give up a right to seek a variance. Everyone has a right to seek a variance, and that wouldn't be within our power to say, you must agree today to never apply for a variance in the future. But you don't need a covenant because it's illegal unless they get a variance. Follow?
Okay, yeah.
So I think as long as the plans they submit are clear that it will
Correct.
not include it, it then becomes an enforcement issue. If they ever threw up the 3-foot addition, code enforcement would go down
Okay.
there and say, this is illegal. You did this without a variance. And I'm not sure they'd ever get a variance. That's a different
they would get-
question. but
They
they'd
would
have to
get a
apply for it.
They
violation.
would get a violation, of
Yes.
course, yeah.
We could have a clause in resolution that there's initial submission shows.
Sure.
Well, let's-
Yeah,
You
you
could
could,
concern him on the board, the applicant withdrew the netting. of
Right.
everything.
to have a record that it was,
Yeah.
that it was discussed and
I think
removed.
that's the kind of thing I'm
That's
looking
fair.
for, and, we will have a resolution of that type, yes.
That's fair.
You guys okay with that in the resolution? Okay.
I also know it's a big social sport, so have fun.
It is a social
Yeah.
sport. Yeah, the Padel, is or paddle.
Right.
Like they have the communities are built around it. It's
My
pretty funny.
understanding,
Yeah, yeah.
I might get one.
Me too.
So maybe, Mr. Chairman, maybe the resolution would just be to poll the board and direct staff to prepare a written decision if that's the will of the board. How about that?
Rocco, would you like to add your comment to this, and will you?
I think it could be identified in the resolution that, we had a discussion and it was agreed to that 10-foot limit. And like Tony said, it needs a variance and we shouldn't restrict, their ability to get one.
Dave, okay?
As long as the landscaping issues are raised or dealt with, I'm fine.
Yeah, I'm good with it. Okay, so we have everybody in
Is that good enough?
agreement.
For what you
That's
guys were
great.
looking for was the
Well, we need
comfort.
to order it, and we wanted to make sure it was good by the board before we order, because it's a quite a lead time.
I think you're hearing
Are we
that.
good to order it? That'd be
You've
the-
got that.
Thank
I
you,
think you're
appreciate
feeling
it. That's great.
Feel confident.
Excellent, yes.
Without the net.
Thank you for accommodating us
Thank you, yeah.
and
yeah.
educating us.
No, thank you. We
I
appreciate
mean,
it.
you're our first. Thank you.
Thank you. Have a great evening.
Okay. 220 Dune Road, West Hampton Beach.
make a statement before we start? So
Please.
Jim, this is the first time on.
And
It's not,
officially on.
it's not officially on, it's not meant to be a, a full presentation. It's meant to just introduce the board to the project.
Sure.
So keep it, in the conceptual way.
Sure.
And then we'll have a discussion about sort of the process, and secret, and religious uses and stuff like that, okay?
You want me to sit over there just to make it even more informal?
No. You wore,
Maybe
you
take
wore,
the jacket off.
you wore a
and
tie today.
Take
so
the
you're-
jacket and tie
you're
off.
already formal.
All right, well, good afternoon, or evening, or whatever it is. Um, For the applicant, Jim Hume, 323 Mill Road, West Hampton Beach. So we're here to give a brief introduction to our proposal for a change to the function at 220 Dune Road. The application is indicated in the name of Brenda Ostreicher, who is the actual owner of the property. My client, who is the effective applicant, is a contract vendee under a contract to purchase the property. They are looking to, I'm sure you're familiar with the activities at 112 and 114 Jessup Avenue as far as religious services go. My clients have tried for many years to purchase those premises and to make some improvements, et cetera, but it just, for various reasons, hasn't worked out. So the opportunity to purchase 220 Dune Road has presented itself, and that's what we're here to talk about. In anticipation of moving forward on several fronts here, we submitted a set of plans to the building inspector for him to identify for us the necessary impacted zoning relief. And based on the project they submitted, it was threefold. First of all, it was the religious use that we plan to put to a residential residential property to. The second issue was the parking, and the third issue was a small reduction in the buffer. Two of the three are demonstrated on the. Do we have the site plan that we can? I don't know if you can see that, but you have a copy of that
Yep.
in your packet as well. So just real quickly on the religious side of things, there is a brief argument in the papers that we submitted about why we believe that religious use, even in a residential zone, is not a use that can be prohibited. But that doesn't preclude the board from exercising its planning authority to make sure that the use is appropriately planned and anticipated. And again, the court cases have said that issues like traffic and noise and property values are not bases for excluding the use completely, but they may be bases for what you say about the actual plan that we're presenting to you. I think that we can learn a bit from the use that the client has put 112, 114 to over the years. And the main complaint when I reviewed the history of the use of that property was the failure to get a tent permit on a number of occasions. But there was not really a big record of parking issues in the village files concerning that. This does seem to be a congregation that says that they walk on the Sabbath, and they do in fact walk on the Sabbath. But the parking is kind of a twofold thing. Even if you accept the fact that on the Sabbath and the high holy days that the people are generally walking and not driving there, there are certainly other events that take place in religious institutions such as weddings and things of that nature. We recognize right up front that there is no parking on Dune Road, so we can't do that. And so we've been talking, and we're not really ready to present anything about that yet, but we've certainly been talking about what alternatives we can propose to the board to satisfy, I'm sure, your concern about that. And the third thing was the buffer. There are some areas there and where the buffer is in fact less than 10 feet, but if you take a close look at the plan, you'll see that it's landscape is quite robust. And even though it may not be 10 feet, it's pretty thick, I guess it was one word that I might use. So that's just kind of an introduction from my perspective. I'm going to ask Josh if he could, the architect, if he could just quickly take us through the structure itself, so you have an idea of what it is. It's basically a house of worship with an apartment in it. I'll leave it to Josh.
Hi, everybody, Josh Rosenzweig, principal at APD Architects, 44 Quogue Street, Quogue, New York. It's good to see you all. We were invited to be a part of this project, and with a focus on turning the aesthetic of this home with assembly use on the first floor into something that was very much resembling the character of the neighborhood. And while this is not the Architectural Review Board, it is important to sort of understand the nuance of the design intent. More of an agrarian aesthetic, traditional roof lines, set with many landscaping features, as you'll see in Brett Wellman's landscape plan in a little bit, but a home that essentially is indistinguishable between simply just a home or a home with additional assembly uses on the lower level. However, it has been designed fully for commercial building code standards. One of the initial approaches in this was the understanding of capacity and flow, sanitary systems, of course, and what we needed to meet the requirements of the Suffolk County Department of Health. All things that are going in a very good direction at this point. Not that it's as important to the board, but understanding that the wastewater, execution of a property like this under commercial standards does require space and planning. And as part of the planning board, to understand that it does meet all of the setbacks, and we're using all of our real estate in such a way. So all those things are currently going well. Just to talk a little bit more about the exterior shell. Again, character of the neighborhood: shingles, cedar shingles, yellow cedar, vertical planking. Not black, but more of a charcoal window and door aesthetic. Something that blends into the environment and the landscape of West Hampton Beach, who I've been fortunate enough to do several homes in, and believe that this will be nothing but complementary to that. One thing that's important, though, and again, your mandate's not just to look at the architecture, but the whole site. I think it's really interesting that you don't see any commercial equipment or facilities on the roof. What you see is what you get. To hide any additional equipment that one would see with a building that has more of a commercial requirement, that sometimes takes us out of the smaller scale of the domestic sense, and our equipment needs to be a little bit bigger. Not because we need it on a day-to-day, but because the commercial standards are more robust from a New York State Building Code aspect than the residential building code standards. There is a parapet wall that's about 4.5 feet up between the twin gables on the roof line, where everything is concealed. You cannot see anything from any vantage point in West Hampton Beach unless you're on a drone above looking down at the roof. I think that's important. If we think about the floor plans, this is in total a 6,500 square foot residence. This is the lower level, looking Dune Road side there, the bay on this side here. There are handicap accessible ramps that have been designed to be low visual impact. Everything, again, is complementary to the scale of the materials. Coming into a foyer, and then as you continue towards the bay side, there's a large study for assembly and congregation, and a large deck. In the packets that we provided, we not only did exterior elevations, but photorealistic renderings so that you can really understand what the entire building looks like from all vantage points. On the second floor of this design, it is simply a home. There are 5 bedrooms on the second floor, a nice open staircase. There's nothing commercial about these details. This is very much of the residential tone in terms of architectural design and vernacular. There is an elevator, of course, that takes you to the lower level, first floor and second floor. Hallway, there is a living area, and 5 bedrooms. There is a deck off the back. Once again, with such a beautiful piece of property, you want to enjoy those views. And a lower level, which I don't have the plan on the big poster board, but it's in the packets, that just shows a garage, some storage areas, and of course the elevator access. This isn't a FEMA designation. Thanks, Jim. And FEMA designation. And right now, even with the change in the code from January 1st with the additional 18 inches of freeboard, this building does respect that with a first floor elevation at 16, almost 2 feet higher than even required now with the more robust FEMA code. It's, you know, part and parcel to the idea that we do want our garage to be on the lower level, which always pushes up the first floor. But we didn't really have any ridge issues because at the end of the day, scale-wise, while it may seem north to south long here, it's very much a very small scale of architecture. It's not too robust or overly, you know, a lot of broad sides to the building. And I think that's really just a little bit of an understanding of the design and the intent. And Grant, if you want to say a few words about the site and accessibility and parking as we at least have it today, that would be great.
Hi, Grant Wellman, landscape architect. I'll first just kind of walk through the circulation and then we can get to the plantings. So we have the main access drive coming off, easy pull-in parking, 40 feet, easy turnaround and out. We do have a couple of security bollards in the plantings here that we plan to integrate into those beds. Along Dune Road here, you'll see we have our first accessibility route, and that's to get you up to the first floor without going through the elevator if one chooses to. So coming off of Dune Road, and we have this very interesting serpentine switchback route for that we designed with plantings in between each row. So that's going to help accomplish a couple things. One, of course, our main objective, getting everybody up there safely, but it also allows us to bring in this tiered landscaping and really hide that from the street. So very low visibility. We'll have evergreen screening along the front there. Our second route would be if one were to park in the accessible spot, they could come down this sidewalk, go into the elevator access that Josh just showed you, or they could come back to this second access door here. We do have a security gate on the east side of the property. If I'm to hold the plan like this, that goes back to this this entrance here on the east side. Landscaping wise, we have definitely some very robust evergreens down both sides. Great existing coverage that straddles the property line with the neighbor to the east. On the west side, we have the Bath and Tennis Club. So we'll just be doing a row of evergreens along there. Right now, I believe it's just a chain link fence and some sod and then their parking lot. All of the plantings around below that are, you know, really just filler material, but intended to be native landscaping, you know, switchgrass, bayberry, that sort of stuff, very much in keeping with the area. And lighting wise, we're aiming to keep it as minimal as possible with bollard lightings. We're trying to get away from any pole mounted luminaires, anything that looks commercial, but providing enough of those to fully light the parking lot at night. And then drainage wise, we have our drain fields and French drains down the side, providing full stormwater drainage for the whole site.
I got a question on that. Would it be the east facade, that long walkway that has a security gate at the front? What is that for? Is that for service?
This gate here?
Yeah.
Yes, it's for service. You know, I could imagine possibly the mowing crew using that to, we have a modest amount of lawn, but getting back to that lawn.
Okay. Mm-hmm.
And then we also have some bike racks back there.
Yeah, I saw those.
So
yeah.
that would be the other function for that.
What sort of issues is there with security as far as protection against vehicles being driven in to cause damage to the facility or something of that nature? Is there
well, let me kind of rephrase that. I don't know if we hope there's no issues at all, but our solution for any possible issues would be the security gate that would prevent vehicles from coming up the driveway when they don't have it open, of course. And then we would have security bollards mounted in grade where one could possibly drive a vehicle around that gate if they were to go over the plant bed. And then on the east side with the aforementioned security gate, and then we have the septic wall itself.
Well, there's a lot to digest here. I don't know that, speaking personally, I don't have any comments at this
No,
time.
you weren't, you shouldn't. This wasn't meant to lead to comments yet.
Yeah.
I did want to talk about a couple things though with the board. One is process and one is just the idea of how to review a religious use. So maybe we could talk about the process first. This should be done, this is subject to seeker. There's dual jurisdiction by this board and the zoning board, right? The zoning board's primary jurisdiction is going to be over the use because technically under our code, it's not a permitted use as of right. So they are going to have to apply for a variance at least for the use. And I think the applicant's going to have to work with Brad to figure out what other variances might be needed, at least on paper, right?
He's responded in writing. In fact, filed a zoning board
So you know what the variances are at this point? Okay. So next week it's gonna be on for just a preliminary meeting with the
Well, I
zoning
mean,
board. But they
let's
can't
talk
even,
secret. Why would we be why would the planning board take that?
I'm not saying you should.
Okay,
My point is to introduce the application to you,
okay.
to introduce the application to the zoning board and see which board would like to take lead agency. I mean, in the past, when we've had dual jurisdictions, a lot of times we look at who's got more of a discretionary role in the process. Probably in this case, that might be the zoning board. But that doesn't mean you're not as equally capable of doing the secret review. So I think that is one of the questions, you don't have to answer it tonight, but to think about whether this board would want to be lead agency or.
We never want to be lead agent.
Don't say that. Oh, come on, you
We
love
always
it.
seem to be.
We never
The
want to.
other thing, the other thing, and one of the reasons why this board tends to be lead agency more than
It's their fault.
is because of these three. Because you have a
Yeah.
planner here at every meeting, you have an engineer here at every meeting, and a building inspector, and the zoning board only has the building inspector at every meeting. So you do have the extra consultants at every. That doesn't mean that the planner and the engineer can't be authorized to participate with the zoning board too.
Who has to do that?
Well, we'll figure it out. It might just be getting an agreement from the trustees, which they'll go along with if the zoning board's going to be lead agency. I would want the zoning board to have access to Britton and Ron too. So we would arrange that. That's not a problem. So it's a matter of just think about it. Really, I don't need you. This isn't on for tonight to ask you, do you want to be lead agency or not? It's just to point out that there's a choice that will be made soon. And maybe think about at least that initial question for the next meeting. Maybe by the next meeting, we'll have some feedback from the zoning board, see how they feel. So that's the main issue. And normally when we have variance applications coupled with site plan applications, we do eventually do a little bit of bouncing back and forth, right? So, Jim and the applicants might spend some time in front of the zoning board discussing the variances and seeing if the plans are going to change a little bit, then come back to this board to talk about them, and then go back to the zoning board. You know what I mean? That happens all the time when there's dual jurisdiction. So, and I assume Jim is comfortable with that. He's done it before. Yeah, he's done it before, and so it's not going to be an instant process on either side, either the zoning board or planning board. But the very first step is going to be secret, is to get that going, because neither board can act until secret is done. And mean, you're gonna have to, Jim, whoever's the lead agency, work with them to figure out what the initial issues are that they wanna look at. I'm gonna guess that you would like to avoid any kind of pos deck, so you'll wanna work with the boards to figure out what it is that they wanna see early on and try to address that. But that's basically the process.
Why wouldn't we want to be the lead agency? I mean, you know,
It's a dirty job.
I don't know. If you like secret, it's a fun job.
all right. I think
Dirty
pretty
job
I
that
like
somebody's
secret,
gotta
so
do.
I think it's a good thing. I think Britain would say, hurrah to secret. Right, Britain? Hurrah.
Well, we thank you for a very enlightening presentation, and we look forward to working with you.
I do want to talk one more thing. So I
Okay.
do want to talk about the religious use stuff because Jim brought it up, and I've known this application was coming, and so we don't get a lot of applications like this. We have had some applications for the other synagogue for littler things, but this is kind of an important one, and so we have spent in my office, and I've sort of had the luck of having a law intern who's sitting in the back of the room, future lawyer back there, who's done a lot of research on this type of stuff and has helped me figure out what are the standards that are going to apply. And so I did want to hand out it's a very much a summary of the rules that are going to apply and talk about them just briefly. And Jim, you can have one too. And part of the reason I wanted to do this, Jim, was to be as transparent as possible so that you can weigh in also. You have as much a say over the standards as anybody else. So, Megan, you can put this in the file. So I think the way Jim posed it is sort of the right, I mean, he generally described it correctly, which is that religious uses are not exempt from zoning, but they are given certain flexibility that no other uses get other than educational uses. So in New York law, there's two classes of uses, educational uses and religious uses, that get a presumptive, they are considered presumptively beneficial to the village, to the character of the community. And so the courts have created special rules that they're not in any statute. It's not part of, for those of you who know much about the way zoning boards work and the five-factor test, it's not part of the five-factor test. It's not part of any statute. It's a matter of balancing the municipality's interest in protecting the public health, safety, and welfare with the religious institutions' right to exist. And that's constitutionally protected. So these rules kind of derive from a greater power, so to speak, both the state constitution and the U.S. Constitution. So the main thing
Not the greatest power.
I said greater power.
It's a higher power.
Greater power than the statutes, anyway. And me. The main thing that this board, I think, is going to have to be focused on are conditions, because what all the cases talk about and all the rules is that the conditions are where you use the conditions to balance the institution's right to exist, but also protect the public health, safety, and welfare of the community. And so you already do that. This board is well accustomed to sort of looking at the site and trying to come up with conditions that do that. I think it's a little bit more different for the zoning board because they have generally a different realm that they look at. But for your board, you already do this kind of task your interest is not in the use itself as much as
The impact.
how to regulate the impacts of the use. So I don't think this is going to be difficult.
Gracefully secreting.
I don't think this is going to be
This is a
difficult.
secret.
And you're you're gonna have legitimate questions to ask, and that's why they're here. They're gonna have to answer them and make sure that, the impacts of this use are gonna be protected and the community's gonna be protected and, um, but that is, basically the conditions and, there are gonna be some conditions that are benign. If you think about conditions that are neutral in terms of religious use, so like landscaping would be a very good example. Landscaping is not gonna impact the religious use, I assume, unless there's something I don't know about, this particular religion. But, that's a completely neutral element that you already look at. And, presumably you'll be free to look at the landscaping without even worrying about how it impacts the religious use.
Right.
There are gonna be some where it's gonna cross over, and that's where you have to be mindful of how to balance these conditions in a way that, address the impacts of the use without fully excluding the proposed religious use. And so, we did look at, Jacqueline and I looked at examples of how other boards have treated it. And, for example, capacity limits are allowed. So generally, if a site can't handle more than a certain number of people, the courts have allowed villages to put capacity limits on them. But then when you get into other conditions that are designed to kind of micromanage the religious use, that is a no-no. So, getting into.
Wasn't capacity limit a religious impediment?
It can be, but it's also a legitimate zoning concern. And so
Okay.
that's where the balance comes in.
I see.
I'm not saying you should, but let's say, I'll give a good example. Let's say they say we want to have 1,000 people using this property, right? It's gonna be hard to justify 1,000 people using a property this small with 7 parking spaces and room in their building where they're showing 80 seats. That's not what they're gonna be asking for, but there might be some point between 1,000 and 0 that you determine and the zoning board determines this site couldn't handle more than this number of people. And based on what they say, that may be a reasonable condition. Like, you will be asking them for information about how many people are gonna be, do they think are gonna be using this site, and trying to determine if that's an appropriate number. It may be. So the answer is yes, it could impact it, but it may also be a legitimate use of the zoning power. So, those are the kinds of things to think about. And there was one case that we found where the court said it was perfectly reasonable to have a capacity limit. But when the board started getting into, we also want you to have a number of families as members of your community, said, no, you can't get into saying you can only have 50 families as members. You can put a capacity limit on the number of occupants, but not limits on the number of families who could be members. So that may be like a reasonable way of looking at it. You think about the use of the land, right? Occupancy numbers is a measure of the use of land, but you don't want to micromanage how they do their operation to the point of getting involved in their religious use. Okay? So that's
Yeah, they're
just
trying to limit the rabbi lectures to 1 a week.
yeah, right. That
Nice
was
drawing.
that board in that case tried to limit the number of lectures and the number of attendees for lectures.
That
to
didn't
say,
work out.
no,
Or
it didn't
the
work out for.
The membership for up
So-
to 50 families.
That's why I say micromanaging the
Well, we're not in that
exercise,
case,
and
no.
you're not. I know that, but it's worth knowing that you do have some power over conditions, but it shouldn't be abused in a way of getting
Being
into
ridiculous.
the details of their religious operation.
Can't believe they went to court with that.
Yeah, well,
Okay, well, once again, thank you for the enlightening presentation.
Thank you.
We have a lot to consider, and we look forward to working with you in the future.
and you guys will be there next
Yeah.
week at the zoning board.
When do we decide, like, public hearing and that stuff? Not yet, or we?
We have to deal with secret first.
Okay.
I think the structure looked good. I like those bale casts, the way the roof spins out, sweet.
The recording, people weren't interested, just the back, the document test, that was something generated.
Yeah, my office generated, this sort of a primer almost on the rules, and it should be publicly available. We're not hiding behind anything. We want this to be as transparent a process as possible, so.
It's a point of comedy, some of those.
Well, this way, Jim, if you disagree with the way we've characterized the law, just say so.
Pretty much where I'm at. Thank you.
Okay, thank you. Okay, we have minutes to accept. Need a motion to accept the minutes as written.
Make the motion.
Second.
All in favor?
Aye.
Need a motion to close the meeting.
So moved.
All in favor?
Aye.